The Supreme Court.
Good morning, everyone. Good morning. Thank you very much. Please be seated.
Good morning, Your Honors.
Good morning. Please call the case.
The matter before the court this morning is a case entitled John Echeverria and Karen Pratt v. Town of Tunbridge, case number 23 AP 291. Representing the appellants, John Echeverria and Karen Pratt, is attorney Jeffrey Vitt. Representing the appellee, Town of Tunbridge, is attorney Steve Codius. Seated at council table with attorney Codius is attorney Michael Tarrant.
Thank you very much. And good morning, counsel. Good morning again.
Morning.
If you would, please introduce yourself and identify your client for the record before you begin.
If it pleases the court, my name is Jeffrey Vitt. I represent the plaintiffs in this case.
Thank you, Mr. Vitt.
There are two issues that I want to talk about today. The first is the ripeness issue, and the second would be collateral estoppel. And I've reserved 2 minutes for a rebuttal. This case,
I think it was, even though you put in your brief the merits of this controversy, that was just background information. You don't expect it to lay, but you would probably do it.
I do not intend to talk about the merits. It's the topic that takes a little time and energy, and that's not where I'm going today. So, on the issue of is this case ripe, we believe it is for two separate and independent reasons. First, the town has created a threat of a defect in title by insisting that it has the right to invade the plaintiff's land and perform maintenance on the public trails.
So you say a threat. Have they recorded something against the property?
They haven't filed anything, but the assertion of a right to go on their trails has been stated in public meetings. It's in the record. I mean, it's not exactly a secret. I mean, they're not holding this, confidential in some way. They're saying we have the right at our choosing to either go on the land ourselves or to deputize citizens in town to go on the property and do the maintenance work that we think is necessary.
I'm sorry. No, please, go ahead. Well, I just want to follow up. How does this create a cloud on your client's title? That's the question.
Well, it's not it's a threat of a defect. I mean, there's three cases that we rely upon: the Gladson case, the Watson, and the McAdams case, which says essentially, look, if a government body, and it can be private parties, but if a government body says we have the right to come on your property, we have the right to go to your condominium and to perform new inspections, or we have the right to say they're abandoned roads. We say we've got a right to that. And we say no, you don't. So there's no formal action that they've taken in terms of recording something. But we think these three cases stand for the proposition that there is a threat of a defect because right now we maintain that it is our right and not the town's to do the maintenance work. The Vermont statutes
Do I
simply,
understand that's doing no maintenance work? That is, you would rather this rail really go away?
no, I don't want it to go away. I mean, right now,
But I don't understand under what legal principle you got an obligation to maintain a public trail over time
there is no, we are not obligated to do it. But to the extent that any party has the right to do it, it's our right and not the town. So far, before this controversy arose, the plaintiffs decided, for perfectly understandable reasons, they wanted to take the public trails, particularly the Orchard Trail, and that's the one that we're talking about because that's the one the bikers wanted to use. They wanted to maintain that trail. So when trees fell, they cleared it up. When there was brush, they took it off. They maintained it so that the public could use it, and they encouraged the public to use that trail. But they're not obligated to do it. Indeed, there's a public trail on the property that's essentially not maintained and not very usable.
So, Mr. Bay, you're using the word public trail today in the
The
briefing.
legal trail,
You use the word legal trail.
that's the term I should be using.
And what actually is a legal trail?
A legal trail would, in this case, would used to be a class 4 road. It stopped being used as a class 4 road, and it's classified as a legal trail. And the town says, you know, legal trails and class 4 roads are synonymous in terms of right. That might have been true until 1986, but the legislature, and I'm getting into the merits, and I should try to, you know, steer clear to the extent I can. The legislature changed the definition, and we say that as of 1986, the town no longer had the discretionary authority to perform maintenance on that road, on that legal trail.
And that's really the issue here is the right to maintain.
That's
We're
right.
not talking about a right to enter.
Right, it's the right to maintain.
So, Mr. Bed, you filed literally on the eve of the hearing, a motion that references a select board meeting that occurred on May 14th.
Right.
Okay, so you don't have a transcript,
Right,
but it's based on a recording, correct?
based on the recording.
Right, and you're asking this court to consider that motion in this instant case. But you were aware, were you aware that this was going to be addressed at the May 14th select board meeting?
No. And the town has a knack, and I'm not saying they do it, I'm sure they don't, but it happened before the trial court when in August, they adopted a new policy saying we have the right and we can designate or delegate that right to volunteers. And we certainly we're not expecting to have the town pass a resolution that removed any doubt that it intends in relatively short order to have the town crew show up on the property and do the maintenance. As soon as the trails dry out sufficiently, they intend to have a crew show up and cut trees, do whatever we don't know what.
In the select board minutes, because I don't see that
It's
reflected in your motion.
It was what they said. I mean, what we have is the recording, and I hope we gave you, and if not, I'll certainly provide the place in the hearing, in the meeting, where this was stated. Let me just get it, hold on a second. The motion was to get either the Trails Committee or the Trails Stewards to give them advice when they could allow maintenance so that we could allow maintenance so those trails can be opened.
Are you referring to the appellate volume now that you're reading from?
No, it's what I'm reading from is the portion of what we essentially transcribed. I mean, we took notes and wrote down what.
But that's not before this court in an appellate volume or in a motion, correct?
It's not in, the motion asked the court to take judicial notice of the
I
recording.
understand that, but my question is, what you're referring to now, what we're reading from, is that in the appellate volume? Or, so we don't have what you're reading, correct?
You have a recording, and if you listen to it, I believe that I've accurately recited what it says, but what I would ask is there'll be minutes in relatively short order. I mean, in a matter of weeks, maybe shorter. And as soon as the minutes are available, we would propose to submit them to the court.
Counsel, I'd like to go back to something that Justice Dooley touched on.
Right.
You're arguing that the right to maintain these trails is solely your client's, correct?
Yes, that is that the town prior to 1986, the town had an argument that it had a right to maintain. After 1986, no, there is no right of the town, period, to show up on this trail and do maintenance. That's our position.
And the right to do maintenance is exclusively yours.
Yes, but there's no mandate. I mean, that is,
Well, that's my next question. If you have the right, what's your obligation?
I don't think there's any obligation. I mean, public trails, some are maintained, there's legal trails, some are maintained, some are not maintained. But I don't think we have an obligation to do it.
Okay, so you prevail here, then the trail becomes choked with trees and so forth. That's just the way it goes.
Well, the reality is, if we prevail here, the trail will be impeccably maintained because that's the way we had it, that's the way we kept it, that's the way they intend to do it. They will maintain the trail if we can resolve the issue of bike use. I mean, look.
So how important is the use in this? And I don't want to get into the merits, but there's use from four-wheelers, there's use from motorcycles, there's use from electric bikes, there's use from bicycles, mountain bikes, runners, walkers.
A
So
number of those things are not permitted on the trails, you understand, at all. I mean, on these trails, they're not permitted.
right. So how important is use here? And can use be limited to walkers and trail runners?
The town has, look, we don't claim that the town has any impediment. They can decide who gets to use the trail.
They could throw it up.
I'm sorry, what?
Could they throw it up? Could they throw up the trail?
What do you mean throw it? I'm sorry.
Abandon it? Could they
Oh.
legally abandon it under them?
Sure. Absolutely.
Yeah.
They have no obligation, zero.
Right.
And a lot of these trails are not maintained. I mean, you know, if they're not maintained, so be it. You know, nobody's at fault.
So do I understand your position? This is what makes this so confusing, and yes, we're back on the right, who's got what right, is that the underlying dispute, what brings you here and are upset is that the town has allowed uses you don't approve of. But somehow the legal issue has nothing to do with uses, as you just said. It has to do with what's the condition of the trail. So that I expect that what you therefore will do is find a way to block the kind of things you don't like if you are in total control of the maintenance of the trail. Is that what I understand is going on here?
That's not entirely accurate. We don't intend to block the use of the trails. In fact, the plans have actively encouraged use of the trail, walking, cross-country skiing, for a whole bunch of purposes. Their position is that given the wetlands, given the intensive use that would be associated with, you know, bike events occurring, that bikes are not consistent with the condition of these trails. What are you going to have 20, 30 bikers going through wetlands? No, they think it's not appropriate, but they will certainly continue to maintain this trail. The dispute, and you're absolutely right in saying, yeah, there's been a dispute. The town has been pushed, understandably, I suppose, by the bikers saying, that's a nice trail, we'd like to use it. And we say, we don't think it's appropriate.
And when you're talking bikers, you're talking about cyclists, correct?
So, yes.
Mr. Chief Justice, may I ask another question?
Oh, please, I'm sorry.
No, that's fine. I just saw Mr. Vitz like go on.
Right.
Thank you. So, Mr. Vitz, you have relied on, I think Watson and Gladchen, to support your arguments regarding ripeness.
Yes.
So Gladchen had significantly more improvements done on the property, and clearly AT&T was intending to put up the antenna. There was all that work done there. And this case, the town hasn't taken any affirmative action on the properties. I don't find the ruling or this court's decision in Watson as based on rightness. So perhaps you can help me to understand why you're relying on those two cases.
So in Watson, there was a question of, you know, could they come and do additional inspection, right?
Right.
And our position is that the government assertion of a right to enter your property and do something with respect to that property constitutes a threat of a defect on title. I haven't had much chance to talk about the reasonably be expected, but that there are two independent bases on which we say the case is right. And in view of the most recent action by the board, it is close to certain, because the trails will dry out, the town will be able to show up with a crew and do the work, and there will be town personnel on that property in reasonably short order. This case is a right case for resolution by the court. Thank you.
Thank you very much. Thank you. We'll hear from counsel for the appellee, please. Come on up. And for the record, please introduce yourself and identify.
Thank you, Your Honors. May it please the court, Steve Codius, representing the town of Tunbridge, along with my colleague, Mike Tarrant. So I think a lot of the questions here have been directed at the dispute that has arisen within the town of Tunbridge between bicycle advocates, as has been referenced, and the plaintiffs. And I think it's important to provide some context here. The town of Tunbridge has been caught in the crossfire of various folks in its town that want to advocate for their interests and have been lobbying the town to take action that supports what they want to see. And the town has been gathering information, has been listening to everyone that speaks at all their town meetings. The plaintiffs themselves showed up to most, if not all, of the meetings where issues about the trails are discussed. And the citizens of the town drive the issues that the town examines and makes decisions on. And so, yes, the town has discussed trails now going on, a few years, but it has never taken concrete definitive action. Yes.
The nature of this dispute, as you are pointing out in the beginning, has been clear from the very beginning, and we are a notice pleading state. Plaintiffs said you can't maintain. They didn't say that you can't maintain because this evidence. We don't require that in our plea. But you now say, oh, and later events occurred in what was a moving case, that is things that happen all the time. They have to go back and constantly replete. That is that consistent with being a notice pleading state?
It is, Your Honor, and I think it's important to recognize that the plaintiffs are the ones driving the case. They choose when to file suit. And here they simply jumped the gun. I mean, they decided to file suit when the issues have been talked about at a select board meeting or several select board meetings. And because these issues had been talked about and there was such a passionate debate among members of the town about whether the trails could be maintained or not, the town gathered information, talked to its legal counsel and asked.
I know that, but they got a legal opinion. The legal opinion said you have a right to do this. And then they proceeded to work forward on the question of how they exercise the right. And they said that we're concerned about this litigation. We understand, but we didn't they effectively state, which is what plaintiff's position is, they have a legal right to do it.
They expressed the advice of their counsel, which is that they thought they had the right to do it,
Yeah.
but that is very different from actually doing it. And I think that defendants
People go to tax statutes by declaratory judgment all the time. And isn't the underlying law, if the statute says you can do this, you can be attacked? Not, did you do it?
I think, Your Honor, you're hitting on the precise difference between an advisory opinion and a concrete actual dispute. I mean, if anyone could simply create a lawsuit, a justiciable controversy, just by saying, I think X, and the other person says, I think Y, you know, the idea of standing, the idea of ripeness, all these ideas of jurisdiction would just go out the window. And so I think that it is really important that there be some concrete action. Otherwise, we will have, I mean, if you imagine in, you know, practical reality of, let's say that the court reverses here, and we go back and we litigate the issue of ripeness, we're litigating in a vacuum. I mean, we don't know what maintenance means in the context of this case between these parties because there has been no maintenance proposed. So the court makes a decision about what maintenance means in the abstract. There's no discovery. It's simply a legal question. And then if and when the town decides to actually take some maintenance action, there's going to be litigation all over again. Does the action the town is proposing to take fit this definition in the abstract of what maintenance could be?
But do these folks have to wait till people from the town show up with saws and axes before this becomes right?
It's a fair question, Your Honor, and I don't think so. They do have to wait until that action is imminent, and
How
that's
much more imminent does it need to be than the
Well-
town saying we're going to do it when the trails dry out?
Actually, Your Honor, that is not correct. It is not a correct characterization of the May 14th meeting, and I think that's an important thing to correct on the record. You know, this is an unusual situation where you know, facts are being presented, you know, at the last minute through a request for judicial notice. But the only motion that was made and passed relevant in that meeting was to authorize trail stewards to go out and examine the trails and make recommendations to the select board about where maintenance could be done or should be done. And the select board retains full discretion and absolute authority to say yay or nay and actually perform that maintenance. So,
Mr. Coney-
and there have, sorry.
No,
sorry,
go ahead.
sorry.
No, you finish, and then I have a question following up on that.
And there have been no allegations that there has been any recommendations made, let alone that the select board has actually entertained or considered such a recommendation. Sorry, Justice Whit.
No apology necessary. So the proper remedy based on that motion, then, the one that was filed in the 11th hour, would be for the plaintiff either to seek to amend the complaint or to file a new complaint, correct?
I think that's right. I mean, you know, these are really not the type of facts that are susceptible to judicial notice because they're nuanced, that require context. If you go back and you want to, you know, listen to this, watch this video, there's a motion made, there's 20+ minutes of discussion clarifying what is actually being done, what should be done, statements made from you know, different persons of interest, and you know, it's not something that can be analyzed in a vacuum like traditionally, you know, the type of facts that are normally subject to
Like the weather.
like a weather report, exactly. Yes, and you know, these are just not those facts. So I think yes, it would, unfortunately, it would have to be you know, a new lawsuit or you know, an amended complaint, you know, in some way, but something before the trial. Not something here on
Can
the.
they do that now? They just filed a motion here in this court saying, here's another smoking gun event that occurred. We think it's enough to get us over the hurdle. Does your collateral estoppel argument therefore no longer apply if they bring another complaint with that fact?
Well, Your Honor, I think the way it would go is, I believe that this lawsuit that's on appeal right now should be either barred by collateral estoppel or affirmed on dismissal for rightness. And the court should not take judicial notice of those facts. And at that time, the plaintiffs would be free to file a new lawsuit and allege new facts. They think that those new facts have push them over the edge. If on the other hand, the court,
Every time there's a new fact, seems to be in this controversy regularly, they have to replead that new fact along the way to be sure they are not then deprived of the opportunity to rely on it.
well, Your Honor, I think that it is really important to recognize that the plaintiffs are choosing when to file suit. They chose to file suit at a very early stage before there was really a ripe controversy. Then they refiled a suit on a second time around when facts had already been litigated and actually didn't make any difference in the ripeness analysis. And here we are with more facts that still, I would argue to you that if you do take judicial notice of all the facts up to today, including the May 14th meeting, of all the motions that have been passed, the actions that have been taken by the select board, the case is still not right. So there has been no concrete action, no threat of concrete.
Mr. Cotis, what's your definition, working definition of a legal trail? And how's it affected by, say, title or ownership and control?
I think this starts to get into the merits of the case, which are really not up here, but a legal trail in this matter is that I think my colleague Mr. Bitt provided a workable definition. It used to be a Class 4 road and is discussed in various statutes with responsibilities and powers. The town interprets those statutes as giving it power to provide maintenance on those trails.
So wouldn't that be a live issue as to who has the right and ability to control those legal trails?
Well, right now it remains an abstract question. And that's how the trial court ruled, and I believe that its analysis is quite sound. The question is not ripened because there has to be some type of maintenance that is threatened or actually has happened. Otherwise, we're litigating that question, in darkness. There are no facts to litigate.
So would you agree that it would clearly be ripe if someone goes out and makes a cut?
I think certainly that would be, much closer to ripeness. It's difficult to say any one thing, but,
Okay, well, then let's approach this from a different
Sure.
point of view.
Yeah.
When do you say it becomes ripe?
I think that if the town takes action or threatens to take imminent action, that would be considered maintenance, under statutory terms, or as the plaintiffs have framed it in their complaint, then it becomes ripe. And so
Somebody shows up with a town of Tunbridge T-shirt on and a chainsaw and makes a cut on that trail.
I think
right.
in your hypothetical, the only question for the court to answer in considering whether that would be ripe is that cut maintenance? And I think, it may well be, but that's not the question we have here because there are no chainsaws. No one's showing up to cut, and there hasn't been any action.
Okay.
But action is part of everyone's interest in this, is to keep the these trails open for, what'd you say, for walkers at this point?
Yeah.
I mean, it's in the town's interest, it's in the property owner's interest. So
I don't disagree with you, Justice Cohen. I think that everyone recognizes that, at some point these trails would need to be, kept in a condition to be used or not used at all, right? I think everyone recognizes that. And the problem here is that the plaintiffs have just jumped the gun. They've started a lawsuit over something that they want an answer to before the town has really taken any action. And there are rules for ripeness for a reason. And, the town welcomes the opportunity to litigate the merits of this case if and when it actually becomes ripe.
And they're seeking an advisory opinion.
Yes, the plaintiffs are seeking an advisory opinion at this point. And I'd like to just touch on res judicata briefly, because I do think that's another really important point here that, the town of Tunbridge, like all small towns, the taxpayers have to foot every cent of their litigation. And, you know, they have to defend every lawsuit that comes at them. Here, there's a lawsuit dismissed, there's a trial court decision that very clearly signals what the answer is on ripeness as to two facts that came up in the middle of the case. And then case is dismissed. 2 weeks later, plaintiffs file the same complaint with just those two added facts. And they say, well, we wanted to formalize, formalize the pleadings. But what it did is it forced the parties into rebriefing everything and having a whole new case when the plaintiffs already knew what the trial court's answer was going to be. And the trial court said as much. You know, you knew what my answer was going to be, and you filed the lawsuit anyway. They had a full and fair opportunity to litigate those facts. They did, regardless of whether they were pled. The trial court gave a definitive final ruling on the merits of ripeness. And that's really all that matters in terms of res judicata. So I would ask the court to affirm on the alternative grounds of res judicata apart from ripeness. If there are no further questions.
All right, thank you very much. The appellant have time?
Felons have no time remaining.
Then please call a conclusion here.
The next